Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights. Okay, this is the topic that we are covering, and basically in the previous lecture we had started the discussion over the enforceability of fundamental rights. Okay, like how does the fundamental rights enforceable in the courts? And we had found out that there is a provision of constitutional remedies. Okay, and this constitutional remedy is a fundamental right by itself, so that it could not be dependent upon the discretionary of the state. Second thing which we have seen is that basically this is the verdict of the Supreme Court that this fundamental right is basically the what is basically part of the basic structure of Brit constitution. Basic structure of the constitution. Okay, so that's the thing. If we take it further, so we could say that this fundamental right could only be suspended during the times of national emergency. It means when the national emergency in the force, then the president of this country could suspend the Article 32. So you could not move to the court for the enforceable of your fundamental rights. But the two articles, Article 20, okay, right against the convictions and offenses, and second one was Article 21, right to life and the personal liberty. Okay, these two articles could not be suspended even when the national emergency in the force. So these are the things that we had covered in the previous lecture. So basically we will start from where we had left in the previous one. Okay, so basically we had seen that originally by the constitution this power grants to the Supreme Court by Article 32, and then by Article 226 to the high courts. All right, but it's depend upon the parliament that if the parliament wants to transfer the power, then it could transfer the power to any subordinate court. Okay, but only the delegation of power would be transferred. Okay, the Supreme Court power of constitutional remedy could not be transferred completely. It means that the government or even the parliament could not bypass the Supreme Court while transferring the powers. Okay, thereafter we had seen that constitution defined the Supreme Court as a defender and guarantor of the fundamental rights. Okay, and basically it has been vested in its two powers, original and the wide powers. So that is the point on which we had ended the previous lecture. All right, so now let's move further. So if we talk about the original one, so it is original because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Like if we talk about the judiciary structure of our country. Okay, so we know there are the three forms. Supreme Court at the top, then comes the High Court, then comes the subordinate court. Okay, Supreme Court, High Court, and subordinate court. So if anything happens with anyone, then in the ordinary cases, the person is required to go to the subordinate court. If he's not satisfied with the judgment of subordinate court, then he could move to the High Court. Even if it's not satisfied with the judgment of the High Court, then he could move to the Supreme Court. Okay, so that is the thing. It means directly you could not move to the Supreme Court or even the High Court. All right, first you are required to visit to the subordinate court or the lower courts. All right, so here what we have seen, that when this is the matter of ordinary cases, when this is a matter of ordinary cases, so generally the person who is the aggrieved citizen or aggrieved person, he could not move to the Supreme Court. But when it's a matter of fundamental rights, so by the power of Article 32, he can directly go to the Supreme Court without applying the way of appeal. Like first appeal to the first file the case in subordinate court, then appeal to the High Court, then appeal to the Supreme Court. This system will be abolished or vanished. Thereafter, if we talk about the white nature, because its power is not restricted to issuing of orders or directions, but also writs of all kinds. Okay, like if we talk about orders and the directions, then basically these having the force, but when we compare it to the writs, then it is less. Why? Because writs is the immediate command. Okay, once the writ is issued for some particular thing, then the thing is need to be done with immediate effect. All right, so that's why it is white. Not only the court can give the usual orders and the directions, but even could issue the writs with immediate command. All right, so the purpose of the Article 32 is to provide a guaranteed, effective, expeditious, inexpensive, and summary remedy for the protection of the fundamental rights. Got it? Thereafter, only the fundamental rights guaranteed by the Constitution can be enforced under Article 32. Okay, and any other right like a non-fundamental constitutional right, statutory right, customary rights, and so on, these are not enforceable by the Supreme Court directly. Okay, I'm not saying that they are not enforceable by the Supreme Court at any way. What I'm saying that directly they are not enforceable. All right, so that's the thing. The violation of fundamental rights is the sine qua non for the exercise of the right conferred by the Article 32. In other words, the Supreme Court under Article 32 cannot determine a question that does not involve fundamental right. So what we are seeing here, like whenever there is a case which has been registered under the Article 32, so one condition is necessary that that particular case must be involved question of violation of fundamental rights. Must be involved question of violation of fundamental rights. Okay, if the case does not involve the questions of violation of fundamental rights, then that particular case could not be determined by the Supreme Court by using Article 32. Got it? That's a thing. So the Article 32 cannot be invoked simply to determine the constitutionality of an executive order or the legislation unless it directly infringes any of the fundamental rights. It means whatsoever the executive order was and whatsoever the legislation was, until or unless these having the directions and these having the intention to infringe any of the fundamental rights promised by the constitution, the 32 article could not be exercised on them. Okay, in case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. What is the meaning of this? Like if we talk about the original form, so we know under Article 32 there is a provision: if there is any aggrieved person who thinks that his or her rights have been affected, then he or she could move to the courts or Supreme Court directly. All right. So it is original. It means that he is not required to appeal to the court. All right. In the ordinary cases. But when we talk about the exclusive form, it means that the right to move to the court while having the violation of fundamental rights is not applicable just in the case of Supreme Court. It is also available by the Article 226 with the jurisdiction of the high courts. Okay, so we can say there are two articles for this, like we had discussed many times: 32, 226. 32, move to Supreme Court. 226, move to High Court. All right. It vests original powers in the High Court to issue the directions, orders, and writs of all kinds for the enforcement of the fundamental rights. Okay. Like even the high courts having the powers like directions, orders, and writs of all kinds to enforce the fundamental rights. It means when the fundamental rights of a citizens are violated or affected, the aggrieved party has the option of moving either the High Court or the Supreme Court directly by using the 32 and 226 article. Got it? Here the things are clear. Now let's move forward. Since the right guaranteed by the 32, therefore the right to move to the Supreme Court where a fundamental right is infringed is in itself a fundamental right. Okay, it means that it could not be take away or bridge away. And even the Supreme Court declared it as a basic structure of constitution. Okay, which means that the availability of alternate remedies not a bar to relief under Article 32. Okay, like if there are the options that the person could move to the High Court also. It means if the person is, instead of moving to the High Court, moving to the Supreme Court. For example, let me give you an example. Suppose this is the Supreme Court. This is the High Court. All right. So 32. Two to six. Suppose there is a person like this one, and he is a aggrieved person. Okay, he had to face something, and now he wants to move to the court for the enforcement of his fundamental rights. All right. So there are two alternatives available for him. Article 32 to the Supreme Court, 226 to the High Court. All right. So if we talk about the general judicial structure. So basically, if we talk about the general judicial structure, so the person will first move to the High Court, then by appeal, he could move to the Supreme Court. That's the thing. All right. But suppose if there is a condition that instead of moving to the High Court, the person wanted to move directly to the Supreme Court. Okay. So just because the alternate remedy is available, the Supreme Court could not ask that aggrieved person that do not come here directly, first move to the High Court or follow the general judiciary structure. Why? Because we know that article is fundamental right by itself. Article 32 is a fundamental right by itself. Okay. So that's why the Supreme Court could not redirect that aggrieved person to visit the High Court first. All right. So remember this thing. It means the ordinary judicial structure, which is generally available for the ordinary cases, this will be bypassed. All right. However, the Supreme Court has ruled out that where relief through High Court is available under Article 226, the aggrieved party should first move to the High Court. It means that it is just an advisory note. Okay. It is not a advisory note. Not a compulsory note. Okay. This is the first thing. Now let's move forward. After this, basically we are going to talk about the rates, types and scope. Like we have seen, to enforce fundamental rights, both the Supreme Courts and the High Courts having the two ways. Issue orders or instructions. Second is issue rates of all types. Okay. So there are two main things: issue orders or instructions, issue rates of all types. All right. So the difference is these are general command and the impact will be seen for some time after. These are immediate command, and the impact will seen immediately. All right. So now we are going to talk about the writs. So the Supreme Court under Article 32 and the High Courts under Article 226 can issue the writs of these, like habeas corpus, mandamus, prohibition, certiorari, quo warranto. Okay, habeas corpus, mandamus, prohibition, certiorari, and quo warranto. These are the writs that could be issued by the Supreme Court and the High Court. Okay. Further, if we talk about it, the Parliament under Article 32 can empower any other courts to issue these writs. It means the special courts established for some specific purposes, subordinate courts. Okay. Since no such provision has been made so far, only the Supreme Court and the High Court can issue writs and not any other court. Okay. It means the Parliament having the power to do it, but they haven't do it. Okay. Before 1950, only the High Courts of Kolkata, Bombay, and Madras had the powers to issue the writs. Article 226 now empowers all the high courts to issue the writ. If we talk about Kolkata, Bombay, and Madras, what is the common factor in between them? Okay, just tell me what is the common factor in between them. You have 30 seconds to think an answer, then I will give it answer. Just apply your brain and find out what is the common factor in them. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So if you apply your knowledge and brain, so you will find out that all of these were once British presidencies. If we talk about Kolkata, if we talk about Bombay, if we talk about Madras, okay, let me write down again. All right, Kolkata was a part of Bengal presidency. Bombay was a part of Bombay presidency, and Madras was a part of Madras presidency. All right, all of these were the parts of British presidencies at some time. All right, so if we move forward, all right, so what we will see that the writs were basically the borrowed one. Okay, these were not originally a part of our constitution. Okay, and these were basically, you can say, taken from the English law, so that's why they are basically belongs to the British Constitution. All right, and when they were the part of British Constitution, so basically they are known as the prerogative writs. Okay, they are so called in England as the were issued in the exercise of the prerogative of the king, who was and still described as the fountain of justice. Like if we talk about this one, so what is the meaning of this? So basically, if we connect it with the historical scenarios, so we know that during the history's time, basically there is a rule of kingdoms. Okay, and in kingdoms there are the rulers basically who were ruling the countries, and they were doing all the three things. Means they were the legislatures, okay, they were the executives, and they were the judiciary also. He will make the law, he will take the action of it, and he will even pass the judicial orders on it. All right, so that's why they are called as the fountain of justice. And if we talk about England, so remember when we were talking about the salient features of the constitution, so I had told you that Indian constitution provides for the republic, while the British still having the monarch. Republic means whosoever would be the head of the state will be the elected person, like the president of India elected. But when we talk about the monarch, so king or queen will be the head of the state. So that's why here it is written down was and still. It means that in the historical time and even in the today's scenario, the British kingdom is in the hands of monarch, king or queen. All right, and they are still described as a fountain of justice. Okay, so these rates wasted with them. All right, later the High Court started issuing these rates as an extraordinary remedies to uphold the rights and liberties of the British people when there is a you can say the wave of relaxation to the individuals. The writ jurisdiction of the Supreme Court differs from that of a High Court in three aspects. Okay, so these are these respects. First, okay, I don't think that we have enough time to discuss this right now. Okay, so what we will do, that we will discuss this in the upcoming lecture. All right, so students, we can say that basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed here and be ready for the another lecture. So with this note, let's end this lecture, and what we say thank you.